Welcome back to Bottomline Africa. We continue monitoring the National Assembly proceedings. Honorable Justin Muturi has just arrived within the precincts of Parliament, and he's set to convene the special sit-in in Parliament in order to discuss the Finance Bill 2018. Now, the process expected in the Finance Bill recommendations, remember the President actually referred the bill back to Parliament with reservations and suggestions for consideration. Among the reservations is that Kenya really needs to get enough money to fuel its particular budget, and he recommended an 8% VAT on petroleum products, while the members of Parliament had actually, through the Finance Bill 2018, said that they want to scrap it off until 2020. Now, this is a bone of contention in Parliament. We'll definitely take a look at this. Now, the legislators who are in Parliament currently will either apply the recommendations made by the President and amend the bill, or pass it as a second time without amendments, or with amendments that do not fully encompass the President's recommendations. Remember, among the recommendations is actually budget cutting in Parliament, and also which affected the National Government Constituency Development Fund. We'll definitely shed light on this. But as we mentioned earlier on, Ken Gishinga, who's a chief economist, has joined us in studio. Perhaps let's shed light on the deficit in Kenya's budget. A deficit of 600 billion. How else can the government actually accrue and reduce such a deficit if not applying VAT on petroleum products?
Well, first of all, we have to look at the wastage that we see in government. There is extravagance. We've heard of people flying first class. We've heard of that's more on a token. But every Kenyan will tell you there is some element of wastage, whether the county government or the national government. Fine, that will not raise 600 billion shillings, but it can raise a bit of it. Now, the big question is, where do we get the rest? And again, we have to look at the primary factors of production. What do other countries do to raise taxes? And I can tell you property taxes is the most legitimate form of taxing. How does it work? Pretty much when you buy a piece of land somewhere in Kajiado, it appreciates. The reason it appreciates is because you have roads coming up. So it's only fair that a bit of that appreciation goes back to the Kajiado county government or the national county government. If we did that, we'd have more than enough revenue. We would not have idle land in this country. We'd have a lot of food production, because for you to pay a tax, you'll always be thinking, I need to do some form of enterprise so that I can afford a bit of this tax. So there'll be no idle land, there'll be no speculating for the sake of speculating, and we'll just see a far more productive country. And I think that's a conversation Kenyans want to have. This is not even just about the VAT. People want to sit back and look at the economic destination of Kenya and ask, what do other countries do? Because Kenya is not the only economy in the world. Clearly, the lessons we can learn from South Korea, from Namibia, from the United States. And I can tell you, you won't find something more consistent than the land value tax.
Okay, speaking of land value, let's just take a look at this particular bill. Are you in favor of it being postponed or scrapped off totally, the VAT, the Finance Bill 2018?
I think there are short-term solutions and long-term solutions.
Is this a short term?
I think for the short term, we do need to suspend this particular tax. Okay. We need to suspend it. Then I agree what Junet says. In the next 1 year, we need to have very deep conversations on areas where we can reduce wastage and areas where we can get taxes, because Kenyans want a holistic approach to this. They don't want a quick fix, because what this VAT thing is, it's a quick fix. We'll apply it. The next day we'll be told VAT has gone to 20%. Then we'll have the same discussion again. People want an end to this. People want to have a deeper conversation. So people are saying, let's suspend it for now. Let's cut back on unnecessary travel, unnecessary wastage, and let's look at the legitimate forms of raising taxes. And I think, for me, that sounds, from an economist, sounds like a very sensible proposition.
Okay, let's just cross over to Parliament and listen in on what Speaker Justin Muturi is saying as he addresses members of Parliament in that special sit-in to discuss the Finance Bill 2018.
Party appoint a day for a special sitting of the House. Close the quotes. In this regard, I received and acceded to a request from the leader of the majority party to hold special sittings pursuant to the provisions of Standing Order number 29, subsections 2 and 3 of the National Assembly by Gazette Notice number 9380, which was published in the Kenya Gazette of 13 September 2018, I gave notice of this special sitting and that of Thursday, 20th September 2018, to the members of the National Assembly. In addition, I also published notices in the local dailies notifying members of the said sittings and the business to be transacted. Accordingly, honorable members, this special sitting is properly convened. Honorable members, you may recall that on August 30th, 2018, the National Assembly passed the Finance Bill 2018. Thereafter, the bill was presented for assent to His Excellency the President in accordance with the provisions of the Constitution and our standing orders. However, His Excellency the President, by way of a memorandum, has since referred the bill back to the National Assembly for reconsideration pursuant to the provisions of Article 115, Clause 1, Paragraph B of the Constitution. His Excellency the President has expressed reservations on A, Clause 2 of the bill on the definition of the term winnings for purposes of taxation, B, Clause 18 of the bill on deferral of the commencement date for the value-added tax on petroleum products, C, Clause 31 of the bill on excess duty proposed to be levied on sugar confectionery and the fees charged for money transfer services, D, amendment to the Betting, Lotteries and Gaming Act on the rates of taxation for betting, gaming, lotteries, and prize competitions, E, Clause 68 of the original bill on the proposed contributory scheme to National Housing Development Fund to enable access to affordable housing, F, amendments to Part 7 of the bill relating to the Miscellaneous Fees and Levies Act on the adulteration levy to be charged on kerosene imported to the country for home use, at G, recommendation for consequential amendments to the Appropriations Act 2018 required to bridge the financing gap in accordance with Section 40, subsection 5 of the Public Finance Management Act of 2012. Now, members, I will resume my seat to allow those members to make their way in. Members making their way in, please do so quickly. Those members who are making your way in, please do so quickly. Members, you can register your presence anytime later. That should not take too much of your time. Consequently, the President recommends amendments to the said clauses and the bill. Honourable members, you may recall that Section 41 of the Public Finance Management Act and Standing Order number 245 provide that the finance bill shall be considered and approved not later than 90 days after the passage of the Appropriations Bill. The Appropriations Bill 2018 having been passed on June 26, 2018, that period expires expires before the ordinary resumption of the House on October 2nd, 2018, thereby necessitating the special sittings that you have been asked to attend this week. Now, members, before I commit the memorandum to the relevant committee for consideration and reporting to the House, I wish to inform the House that my office is in receipt of a letter from the member for Mathare constituency, the Honorable Anthony Tom Oluoch, touching on the memorandum. In his letter, the Honorable Oluoch raises 3 matters on which he seeks direction before consideration of the memorandum. These are: 1, whether where Parliament cannot raise the 2/3 threshold required under Article 155, Clause 4, Paragraph A of the Constitution, read together with Standing Order number 62 of the National Assembly Standing Orders, the effect of the failure results into the President's reservations becoming law, which in effect makes the President a legislator, contrary to the doctrine of separation of powers. 2, whether the reservations of the President, which have not been subjected to public participation in terms of Standing Order number 127, can stand the test of law. And 3, whether the reservations of the President touching on specific parts of the Finance Bill and not the entire bill are constitutional. Honourable members, you will recall that I did give guidance on a similar query raised in the last Parliament in a communication delivered on July 28, 2015, concerning consideration of presidential memoranda and amendments thereto. In that instance, the then member for Rarienda, the Honourable Nicholas Gumbo, and sought guidance from the Speaker on the following matters relating to presidential referral of bills to Parliament for reconsideration. He had sought, first, whether in expressing his reservations and sending a bill back to Parliament for reconsideration upon refusal to attend under Article 115 of the Constitution, the President can make specific proposals for amendment to the particular bill. 2, whether the specific proposals for amendment made by the President should go through the entire lawmaking process of consideration by the relevant committee, including pre-publication scrutiny, public hearings, first, second, and third readings. 3, whether accepting of the text proposed by the President and which has not been subjected to the ordinary lawmaking process as outlined in B above should require a 2/3 majority. And finally, whether the House would be properly constituted if at the time of putting the question on the President's reservations or recommendations, there are less than 2/3 of all the members present in the House. Honourable members, the summary of my communication then, which is now substantively codified in our Standing Order number 154, was as follows. 1, that in submitting his reservations on a bill to the House, the President is not prohibited from including his preferred text of the particular clause, section, subsection, or paragraph of the bill. 2, that just like amendments to bills, the text proposed by the President on a bill did not be subjected to other stages subjected to a bill upon publication, that is, publication, first reading, second reading, and third reading. 3, that any committee or member of the House is free to propose further amendments to the presidential recommendations, so long as such amendments have the effect of fully accommodating the President's reservations, the voting threshold for the passage of such amendment, or indeed the proposal made by the President, is a simple majority as contemplated in Article 122, Clause 1 of the Constitution. Any other proposed amendment that does not fully accommodate the reservations, or indeed a total override of the President's reservations, including his proposed text, would attract the 2/3 requirement. 4, that pursuant to the provisions of Standing Order number 1, Clause 2, the determination of whether a proposed amendment by a member or a committee to the President's reservations would have the effect of fully accommodating those reservations shall be made by the Speaker on a case-by-case basis. And finally, that the absence of at least 2/3 majority at the time of putting the question does not in any way imply that the House is improperly constituted. Once again, members, and allow the members to make their way in. Make your way in. make your way in. You can register your presence later.
We can continue. Now, there you have it, parliamentary proceedings in terms of the Finance Bill 2018. They are actually discussing the recommendations forwarded by President Uhuru Kenyatta following his refusal to actually sign the Finance Bill 2018 into law, thereby postponing the VAT on petroleum products later on to year 2020, where they were supposed to come into full effect. Among the recommendations, as we mentioned, is the 8% VAT on petroleum products. We've seen NASA actually give their conditional support to this particular move by President Uhuru Kenyatta, and will definitely continue taking a look at the proceedings of the special sitting in Parliament. My name is Jesse Rogers. Thank you so much for watching. I was joined by Ken Gishinga, who's a chief economist. Thank you so much for making your time. We've come to the end of Bottomline Africa, but we leave you with the proceedings of Parliament.
Negate or amend the proposed text in respect of the reservations made on the finance bill in a manner that does not fully accommodate the President's reservations. It is not a requirement that affects the quorum of the House at the commencement or consideration of the reservations. In terms of the procedure to be adopted in considering the reservations, the procedures of the House are quite clear. As members are aware, all questions for decision in the House are put in the positive. That is to say, with regard to the President's reservation, the question to be put in the Committee of the Whole House will, for example, be as follows, and I quote, that clause dash of the bill be amended as proposed in the reservations by His Excellency the President, close the quotes. At that point, the provisions of Article 122, Clause 1 of the Constitution requiring a simple majority of members on a vote shall apply. And I put emphasis on the one's simple majority. In terms of procedure, this is exercised by way of collection of votes of ayes and nays, as provided for in our standing order number 69 regarding voting in the House. The chairperson of the Committee of the Whole House will thereupon announce the result of the voice votes. It is expected that any member intending to reject, that is to totally oppose, the proposed text of the reservation, or a member intending to amend the clause in a manner that does not fully accommodate the President's reservations, would rise and cause a division as contemplated in Standing Order number 72, subsection 1, paragraph B, read together with Standing Order number 72 on electronic voting. If 30 or more members rise to claim a division, the chairperson shall forthwith order that the division bell be rung as usual. If after 10 minutes or such further period as the chair may direct, there are 233 members in the House, being 2/3 of all the members of the National Assembly, the House shall proceed to an electronic vote in order to vote and confirm the claim to negate the recommended text of the reservations or amend the clause in question in a manner that does not fully accommodate the President's reservations. Where there are less than 233 members in the House, despite the ringing of the division bell, the members claiming a division will have failed to garner the numbers required under Article 115, Clause 4, Paragraph A of the Constitution, and therefore uphold the earlier decision made by way of a voice vote. Honourable members, indeed, even our courts have made pronouncements on the questions raised with regard to the participation of the President in the lawmaking process. This was the case with regard to the passage, referral, and assent of the Kenya Information and Communications Amendment Act of 2013, the Public Audit Act of 2015, and the Finance Act of 2017, where the courts in separate suits affirmed the constitutional role of the President as outlined in Article 115 of the Constitution vis-à-vis the role of the House in the consideration of the President's reservations. Honourable members, for the benefit of the House, I will cite some of these cases. With regard to the enactment of the Kenya Information and Communications Amendment Act 2013, it was argued in court that the manner in which the bill was referred back to the National Assembly with recommendations on various clauses amounting to the President assigning himself a legislative role, which does not contemplated or provided for in the Constitution, in violation of the doctrine of separation of powers. It was further contended that the referral of the bill to the National Assembly with explicit reservations and suggested alternative clauses and the acceptance of the recommendations by the National Assembly amounted to a usurpation of the legislative authority and a surrender of constitutionally vested power by the National Assembly. And this you'll find in the Nairobi High Court Constitutional Petition number 30 of 2014, which was consolidated with petition number 31 of 2014 and Judicial Review Miscellaneous Application number 30 of 2014. In a decision rendered by a three-judge bench, the court ruled that the petitioners had assigned a narrow meaning to the term reservations that was not in accord with the Constitution. It was the court's finding that it does not expect the President to simply state, and I quote, "I have reservations about this bill," close the quote. Since without more information in the memorandum, there would be nothing for the legislature to consider, accommodate, or reject. This led to the determination that the President properly exercised his constitutional mandate as is vested in his office under Article 115 of the Constitution. Further, honourable members, with regard to the enactment of the Public Audit Act 2015, the court was faced with the question of whether the President actively participated in the legislative process in the manner he noted his reservations, and whether that violated the lawmaking process. And in answer, the court agreed with the decision of the three-judge bench in the Kika case, of 2013, noting that it was unable to find fault with the procedure adopted by the President in making his reservations, which included recommended text that both houses passed when returning it to Parliament. Similarly, honourable members, the court was recently invited to declare that the President, as having overstepped his mandate under Article 115 of the Constitution by referring back the Finance Bill 2017 with reservations, including a recommendation on the reduction of the rate of taxation applicable to betting, lotteries, and gaming activities, as proposed by the House in its amendment to the Betting, Lotteries, and Gaming Act. In affirming the role of the President in the lawmaking process, the court categorically stated, and I quote, "The constitutional power of the President to state what is wrong with the bill can be done without making recommendations or proposals to Parliament to avoid the danger of being perceived to be descending to the legislative arena, which is a function of Parliament. However, to the extent that members of Parliament have the constitutional safeguard and freedom of rejecting the recommendations, I find that it would be unsafe to conclude that they were influenced by the President's proposal," close the quotes. That is in the case of Nairobi High Court, Constitutional Petition number 553 of 2017. Honourable members, from the precedents set by this House and affirmed by the view taken by courts, it is therefore apparent that the claim by the member for Mathare constituency and his apprehension that the consideration of the President's reservation is in effect an unconstitutional fait accompli, which leaves them with no option, is misplaced. Indeed, Article 115 of the Constitution clearly allows the President to participate in the lawmaking process through suggestions made to this House in his reservations. The reservations by the President will be presented as a proposal to the House for agreement, and the House may vote to either include it in the bill, negative it, or amend it, subject to the applicable voting thresholds prescribed under Article 115 of the Constitution. The obligation to raise the voting threshold is left to those wishing to negative the proposed text or amend the text in a manner that does not fully accommodate the President's reservations. With regard to the implication of this higher voting threshold requirement on the legislative authority of Parliament, allow me to quote the findings of the learned judge of the High Court in the case of the Public Audit Act 2015. Quote, "The President's reservations were expressed in his memorandum to Parliament in the form of several recommendations and suggestions that Parliament eventually approved and passed without amendments. the drafters of our Constitution must have intended that the President's reservations should almost prevail when they imposed a higher threshold of 2/3 of members in order to reject or amend the reservations, close the quotes. And that was in the High Court petition, Constitutional Petition number 388 of 2016. Honourable members, the second issue raised by the Honourable Oluoch relates to the issue of public participation on the President's reservations. On this question, I will reiterate my ruling delivered on July 28, 2015 on the reservations not being subjected to the normal bill procedure under the standing orders, since the President is availing himself to an opportunity similar to that enjoyed by members of this House when proposing amendments during the committee stage. Committee stage amendments are only considered during that stage, and are not subjected to other processes that a bill goes through prior to that stage. As a matter of fact, in the case of the Finance Act 2017, the learned judge of the High Court did find that, and I quote, on the alleged non-compliance with the standing orders, the earlier communication from the Speaker of the National Assembly is instructive. It will suffice to state that just like amendments to bills, the text proposed by the President on a bill need not be subjected to other stages subjected to a bill upon publication, that is, publication, first reading, second reading, and third reading. Consequently, I find that there was no breach of the procedural requirements that is found in the High Court Constitutional Petition number 353 of 2017. In any event, honourable members, a perusal of the reservations and the various recommendations contained in the memorandum does not reveal any matter not covered either under the bill as published or covered in the totality of the amendments initially proposed on August 29th and 30th, 2018, in the Committee of the Whole House by the Departmental Committee on Finance and National Planning, the leader of the majority party, the leader of the minority party, the minority party whip, or indeed the other members who had amendments in the order paper during those particular sittings. Indeed, these amendments were said to be a product of public participation. Members, once again, let me allow the members to make their way in. Quickly, please.